Under the Speaker's announced policy of January 6, 2015, the gentleman from New York, Mr. Jeffers, is recognized for 60 minutes as the designee of the Minority Leader.
Thank you, Mr. Chairman. It's an honor and a privilege for me to once again stand on the floor of the House of Representatives and along with my distinguished colleague from Ohio, Representative Joyce Beatty, to co-anchor this CBC Special Order Hour, this hour of power, where for the next 60 minutes, we will have an opportunity to speak directly to the American people about an issue of grave importance to the integrity of our democracy. And that is making sure that the United States Senate fulfills their constitutional obligation to advise and consent as it relates to considering any Supreme Court nomination that President Obama sends up to that body. We know that Justice Antonin Scalia has moved on after a long and distinguished career, though I disagree with almost every single judicial opinion that he has issued. He served this nation well. And now that he's moved on, Supreme Court, which is contained in Article 3 of the United States Constitution, has a vacancy. And it is the obligation of the United States Senate to fill that vacancy by considering whatever nominee President Barack Obama sends forward. Members of the United States Senate take an oath of office to faithfully discharge their responsibilities. And when you look at Article 2, Section 2 of the United States Constitution, which gives the president the power to nominate someone to fill a vacancy on the Supreme Court, it's the Senate that must consider that nominee. And since the early part of the 20th century, there have been 8 different Supreme Court nominees who've been voted on in an election year. 6 of them actually were confirmed, but all 8 of them received a hearing. And so for the life of me, I can't figure out why Senator Mitch McConnell thinks that he can get away with holding any nomination up without even the slightest bit of consideration. And so we're going to explore that here today, and we'll be joined by any number of distinguished members of the House of Representatives and the Congressional Black Caucus. But let me proceed by yielding to my good friend and my colleague, my co-anchor. She does such a tremendous job on behalf of the people of the great state of Ohio and the city of Columbus. I yield now to my co-anchor for this special order hour, the dynamic Representative Joyce Beatty.
Thank you so much, Congressman Jeffries. It is certainly an honor and a privilege for me to join you this evening as co-anchor for this Congressional Black Caucus Special Order Hour. Congressman Jeffries, your scholarship and distinguished talents as a member of the Judiciary Committee have not gone unnoticed. Thank you for leading by example and challenging us to initiate and follow through to sending a message on Senate Republicans' refusal to act on the Supreme Court vacancy. In part, tonight's Congressional Black Caucus Special Order Hour, Senate Republicans, do your job, does just that. As you reflected in your opening statements, Article 2, Section 2 of the Constitution expressly designates that the President has a duty to name and the Senate has the responsibility to advise and consent a nominee to fill the seat. President Obama takes this very seriously. He has stated, quote, "It is a decision to which I devote considerable time, deep reflection, careful deliberation, serious consultation with legal experts, members, Mr. Speaker, of both political parties, and people across the political spectrum. But Republicans have made a decision to completely refuse consideration of anyone that President Obama nominates to the Supreme Court. In fact, they have stated that they won't hold a hearing to vote it before the full Senate. Senate Democrats never acted so recklessly when faced with this situation in 1988, when there was a vote to confirm Justice Kennedy. There was no talk of doing nothing until after that year's election, because it was unthinkable then to leave the court shorthanded for that long, and it remains so now. The power of the court, Mr. Speaker, is reflected in the work it does. Its decisions often shape the policy as profoundly as any law passed by Congress or any action taken by the President of these United States. When we look back to our history, especially African Americans, the importance of the decision handed down by the Supreme Court cannot be overstated. For example, most of us are familiar with Brown versus the Board of Education, 1954, which reversed Plessy versus Ferguson and its separate but equal ruling. Striking down segregation in our nation's public schools provided a major catalyst for civil rights movements and made advances in desegregating housing, public accommodations, and the institutions of higher education possible. After Brown, the nation made some great strides towards opening the doors of education to all students. Unfortunately, the promise of the Brown decision remains unfulfilled in many ways. More than 2 million Black students attend schools where 90% of the student body is made up of minority students. On average, schools serving more minority populations have less experienced, lower paid teachers who are less likely to be certified. A report from the Center for American Progress found that a 10% point increase in students of color at a school is associated with a decrease in per pupil spending of $75. In many ways, more than 60 years after Brown versus the Board of Education, school systems in the United States are still separate and unequal. And we are just not witnessing educational disparities at the elementary and the secondary education level. College enrollment is racially polarized. White students are overrepresented in selective colleges, which have more resources to educate and to support them, while African American students are more overrepresented in less selective institutions. Mr. Speaker and Congressman Jeffries, you see where I'm going with this. This is also why the late Justice Scalia's comments during oral arguments of the pending United States Supreme Court case, Fisher versus the University of Texas at Austin, were so disturbing. He stated in part, maybe the University of Texas ought to have fewer African Americans. These comments are inaccurate and insulting to me and to African Americans. They undervalue the historic achievement of that African Americans have made. Thousands of Black Americans have excelled to the top tier of their universities. Many of them you will hear tonight because they are members of the Congressional Black Caucus. They are scholars. They are the conscience of the Congress, and they represent the diversity of America's best universities, of America's historically Black colleges and universities. There is much more that we will say tonight, and I would like to reserve some more time. But now I turn it back to my co-anchor, Congressman Jeffries.
I thank the distinguished gentlelady for her wonderful thoughts and observations and look forward to our continued dialogue. It is now my honor and privilege to yield to one of those individuals that Representative Beatty mentioned as really a legal giant amongst us, someone who has served this institution well, who understands the Constitution, the notion of separation of powers, and the importance of a fair and equitable justice system. I yield now to the distinguished gentleman from Virginia, Representative Bobby Scott.
Thank you, and thank the gentleman from New York and the gentlelady from Ohio for organizing tonight's special order to call on our colleagues in the Senate to do their job and provide their advice and consent on the President's upcoming nomination to the United States Supreme Court. The Constitution is pretty clear on this issue. Article 2, Section 2 doesn't say the President might or the President should. It says the President shall nominate and by advice and consent of the Senate shall appoint judges to the Supreme Court. Now, there seems to be some suggestion that if it's an election year, he ought to skip that process and let the next president make the appointment. And they say there's very little precedence for a president nominating somebody in an election year. Well, that might be technically correct, but the fact of the matter is there have been virtually no vacancies that have occurred during an election year. I think the last one was about 50 years, almost 50 years ago, and in that case, an appointment was made and considered, and that's the process that ought to take place in this case. The rarity of such an event should not preclude the Senate from fulfilling its constitutional responsibility. There is precedence for the Senate actually for the President nominating and the Senate at least considering the nomination during an election year. Now, Justice Kennedy was confirmed in an election year, 1988, and that was a 7-month process that began with the appointment of Robert Bork to the Supreme Court. His nomination was considered and defeated. And then there was the appointment of Douglas Ginsburg, and we'll just say his nomination went up in smoke. And then the nomination and confirmation of Justice Kennedy. 7 months from start to finish, consider, defeat, another nomination made and collapsing, another nomination made in 7 months. We could complete that entire process by the first Monday in October, the beginning of the Supreme Court session. There is no precedence for the President declining to nominate somebody, and virtually no precedence for the Senate just to ignore a nomination that's made. The people overwhelmingly reelected President Obama in 2012 to a term that does not end until January 20th, 2017, and we fully expect the President to fulfill his duty to nominate a qualified individual to the Supreme Court to fill the current vacancy. A failure of the Senate to act this year would be unprecedented. There's ample time for that to take place. The longest confirmation process for a single nominee has been 125 days. On historic average, 25 days it takes to confirm or reject a nominee. As of today, the Senate has 216 days until the first Monday in October. If the Senate were to refuse to consider any of President Obama's nominations, and the Senate has and they've said we want the next president to make the appointment, there has been no indication that they will give expedited consideration to the next president's nomination. It could well be well into the next year by the time the new justice is confirmed and sworn in. Or even on an expedited schedule, the new president would not be able to nominate anyone until they're sworn in on January 20th. The Senate Judiciary Committee would need time to prepare for hearings, which could not occur until probably February, and then the full Senate would need time to consider the nomination, with the confirmation not likely until probably March. Now, by March of a term, the term is effectively about over. Most of the oral arguments have already taken place, and they're into the decisions. You can't participate in a decision if you skipped the oral argument. And so not only would the vacancy occur through the rest of this term, almost half of a Supreme Court term, it would be well into the next term and effectively through most of the next term. There is no excuse to leave the court vacancy open in what then would be a historic new precedence. There's no precedence for keeping a vacancy open that long. We need the justice appointed. The Supreme Court, the Senate ought to do its job. The President has indicated that he will do his job as mandated by the Constitution. And so the Senate ought to just fulfill its responsibility under the Constitution and consider an appointment. Otherwise, you'll have a vacancy not only through the rest of this term, and oral arguments have been taken place. You'll have the vacancy through the rest of this term. You don't need a vacancy through the entire rest of the next term. There is plenty of time to consider and vote up or down on a nomination. And the unprecedented vacancy that would occur if the Senate fulfills its threat to stonewall any nomination is just unprecedented. So I want to thank the gentleman from New York and the gentlelady from Ohio for giving us the opportunity to just say a word about the importance of everyone in our democracy fulfilling their constitutional responsibilities. The President shall appoint, and the Senate shall consider, advise, and consent so that we can have a Supreme Court justice appointed before the first Monday in October. We have plenty of time to do that. There's no excuse for not doing it, and we expect the Senate to do its job. Thank you very much, and I yield back.
Distinguished gentleman from Virginia for highlighting several important points, including the fact that there is no election year exception in Article 2, Section 2 of the United States Constitution. This is all in Mitch McConnell's mind, cooked up in some partisan laboratory in order to stop this president from being able to move forward and do the business of the American people. We shouldn't be surprised because we know Mitch McConnell stated very early on that his objective was to grind everything to a halt here in the Capitol to try to prevent President Obama from being reelected. Not my words, his words. But here's the thing. President Obama was reelected in an electoral college landslide. And his opponent in that race, Mitt Romney, tried to make it in part an election that was a referendum on the possibility that President Obama would have the opportunity to fill a Supreme Court vacancy. That issue was laid before the American people by President Obama's opponent. And the American people responded, processed all of the facts, and decided to re-elect President Obama, send him back to 1600 Pennsylvania Avenue. The American people did their job. The president is prepared to do his job. The Senate Republicans need to do their job as well. It's now my honor and my privilege to yield to someone who has been a stalwart for justice in this institution, a revered member of the House of Representatives, the great whip of House Democrats, and someone who has the respect of everyone in the United States Capitol and beyond for his service to the House and his service to the country, a great friend to the Congressional Black Caucus, and we're so thankful that he's present here today. I want to yield to the Democratic whip, the Honorable Steny Hoyer.
I thank my friend from New York, Mr. Jeffries, for his excellent presentation. I want to thank Mr. Scott, who, as the gentleman observed, is one of the leaders in this Congress on the Constitution and on the law and on equal justice. I want to thank my friend from Ohio, the gentlelady from Ohio, for her remarks. And I noticed that the chair of the Congressional Black Caucus, Mr. G.K. Butterfield, formerly a judge on the court in North Carolina. I want to first, Mr. Speaker, say that I thank the Congressional Black Caucus for sponsoring this special order. But, Mr. Speaker, I want to tell every member, and all Americans ought to know, this is not an issue related to one group, to one gender, to one race, to one nationality. The failure to fill the vacancy on the Supreme Court will affect every American. And so we rise tonight to ask the Senate to do its duty. Mr. Speaker, I'm pleased to be here on the floor this evening with my distinguished colleagues from the Congressional Black Caucus for this special order. The Supreme Court now has a vacancy, as everyone knows, that must be filled. The American people deserve a Supreme Court operating at full strength. Now, Mr. Speaker, I am old enough to have been alive at the time that John Kennedy was assassinated. Within hours of his death, we swore in Lyndon Johnson as President of the United States because we wanted to make sure that there was a continuity of service. As sad and as tragic as those hours were, the responsibility of having a President of the United States was met within just a few hours. And Mr. Speaker, when a vacancy occurs in this House, and there are, after all, 434 of us left when that happens, the state laws put a time limit on the governor's action to call an election so that that vacancy can be filled. Why? Because the Constitution of those states do not want to have a vacancy exist for very long and have their state or their district not represented. Now, there's not a time limit with respect to the Supreme Court per se. And the reason for that, of course, is the process, as Mr. Scott just pointed out, sometimes takes a little longer, sometimes takes a little shorter. But in 7 months, as the gentleman pointed out, they had 3 nominees considered. 2 were defeated after debate and a vote, and the 3rd was confirmed. The process worked, and it worked in the last year of an administration. President Obama has a constitutional responsibility to nominate a candidate for the court who will exercise sound judgment, uphold the principle that all people are created equal, and must be treated equally under the laws. The founders of our country very wisely made the number on the Supreme Court an odd number, not an even number, because the founders did not want gridlock. Now, we're used to gridlock in this Congress, but they did not want gridlock on the court. And so they provided for a decision to be made by 5 members out of 9. Now, however, with 4 and 4, they will maybe not be able to make a decision. That was not contemplated by the founders, nor would it have been welcomed by the founders. Shamefully, Senate Republicans have said they have no intention of even meeting with a nominee put forward by President Obama. That is not only disrespectful of the President of the United States, Barack Obama, but it is contrary to the best interest of the Supreme Court, but more importantly, to the people of this country. It is appalling that Republicans would prefer to leave a vacancy on the Supreme Court, thereby rendering it, in some cases, unable to make a decision, unable to perform its duties of being the final arbiter when circuits may differ on an issue. If members of one party or another were simply to ignore the other side and refuse to carry out their duties within a divided government, our democracy would break down. And in some respects, it has. We ought not to carry that conduct to the Supreme Court. We must not let that happen. And we must not allow this Supreme Court vacancy to remain unfilled. The court currently has a number, as the gentleman from New York has pointed out, major cases pending that require a decision, not to be remanded to a lower court. Because if that's done, that judgment may stand for that circuit, but there will be other circuits around the country who may make a different decision. Mr. Speaker, the Supreme Court has been a powerful safeguard of Americans' liberty and equality over the past century and beyond. From recognizing the right of every child to attend desegregated schools to protecting every loving couple who wishes to marry, the court has breathed life into the words of our Declaration of Independence, that all are created equal and they are endowed by their Creator, not by us, not by the Constitution, by their Creator with certain unalienable rights. That may be self-evident, Mr. Speaker, but it is not self-executing. And we have established the Supreme Court of the United States to make a decision so that that can be realized. Melissa Hart, director of the Byron White Center, a former member of the Supreme Court for Constitutional Law at the University of Denver, said, if we don't act, it would be a monumental crisis for the development of the law and the need to resolve legal questions. Carolyn Frederickson, president of the American Constitution Society for Law and Policy, wrote on February 19th, quote, it would be unfathomable to go through this term, and as Mr. Scott pointed out, the next term, with a Supreme Court hobbled by a vacancy. Mr. Speaker, let me remind you again, if a president dies, immediately we fill the vacancy. If a member of Congress dies, every state has a time limit in which that must be filled so that democracy can be represented and operate in the way our founders wanted to operate. When the president nominates a candidate to the court, the Senate, in my view, Mr. Speaker, has a responsibility under the Constitution to give that nominee every due consideration. They do not have a constitutional responsibility to approve it, as Mr. Scott has pointed out, but they have a responsibility to consider it. We must not allow politics. We must not allow politics. We must not allow politics to allow the obstruction of this most essential institution of our democracy and the rule of law. I want to thank my friends in the Congressional Black Caucus for leading this special order and for their efforts to hold Senate Republicans accountable for their blatantly irresponsible action on this matter. Mr. Speaker, there is always another election. It may be 2 years away, it may be 4 years away. But if we adopt the principle that if we don't think we can win now, we will obstruct now and hope to win later, America and Americans will not be well served. And I thank my friend for yielding and yield back the balance of my time to Mr. Jeffries.
Thank the distinguished Democratic whip for his very insightful and powerful observations, for pointing out that the very fabric of the United States Constitution is threatened by the willingness of Senate Republicans to abdicate their legislative responsibilities to hold hearings and act on a nomination put forth by the President of the United States of America. It's now my great honor and privilege to yield to the distinguished chairman of the Congressional Black Caucus, as was pointed out by Mr. Hoyer, a former prominent member of the North Carolina judiciary, a legal scholar, a historian, and of course, the leader of the conscience of the Congress here in the United States House of Representatives. I now yield to Chairman G.K. Butterfield.
Let me begin tonight by thanking you, Mr. Jeffries, for yielding time to me this evening, and thank you for your extraordinary friendship and leadership in the Congressional Black Caucus. And I want to publicly thank you for coming to my district this past weekend. You spoke, some would say you preached, at Mount Vernon Baptist Church in Durham, North Carolina, and I thank you so very much for the message that you brought to my constituents in North Carolina. But, Mr. Speaker, moments after the death of Justice Scalia, the majority leader of the United States Senate announced to the country in a tone of defiance that the Senate will not consider any nomination of President Barack Obama to replace Justice Scalia. Mr. Speaker, the American people can see right through this. Though I represent a Democratic-leaning district in North Carolina, I represent many Republicans in North Carolina. Many of them have told me how disappointed they are with the Senate Republican leadership in making this announcement. Senator McConnell is reinforcing the Republican political agenda to disrupt governmental functions when the circumstances do not line up with their conservative philosophy. It is imperative that we have 9 members of the U.S. Supreme Court deciding constitutional issues that are important to the American people. You know, the irony in all of this is that my Republican friends constantly on this floor talk about strict construction of the Constitution. Well, a strict construction of the Constitution, as Mr. Hoyer said a moment ago, requires the president to nominate an individual once there's a vacancy on the court. And the Senate, the United States Senate, has the awesome responsibility of having a hearing and deciding and confirming the nomination by an up or down vote. And so it is absurd to suggest that President Obama should be denied the opportunity to nominate a qualified justice to replace Justice Scalia. The American people should clearly understand that Senate Republicans have a political agenda to pack the court with conservative justices who would reverse years of common sense progressive jurisprudence. And so the Congressional Black Caucus tonight demands Senate Republicans to stop the complete blockade and the blatant disrespect of our president. Senate Republicans' outright refusal to hold a hearing on any individual nominated by the president to serve on the court is an affront to our Constitution and the American people. Such divisive actions undermine our democracy, reduce our standing in the world. This blockade is obstruction and runs afoul of the duties held by those who hold a seat in the august chamber of the United States Senate. I've read that Senator Grassley and Senator McConnell and others will meet with President Obama this week, and I hope they meet. I hope they sit together and reconcile their differences, because this issue needs to be put to rest. We call on Senate Republicans to hold hearings once President Obama submits his nomination and follow the procedures set forth in the Constitution. In short and in closing, the Congressional Black Caucus, the 46 members of the Congressional Black Caucus, and indeed the American people have one message for Senate Republicans: do your job. Don't play partisanship. Don't play a partisan game with the Supreme Court of the United States of America. It's too serious. It's too important. Thank you very much, Mr. Jeffries. I yield back.
Thank the distinguished chair for pointing out that this is a simple question for Senate Republicans. Do your job, consistent with your obligations and responsibilities under Article 2, Section 2 of the United States Constitution. The Senate Republicans' failure to act or consider any nominee put forth by the President of the United States of America is an abdication of responsibility, a dereliction of duty, and it would be a stunning act of legislative malpractice that undermines the rule of law, the presidency, the Supreme Court, the United States Constitution, as well as the American people. I'm thankful now to be joined by someone who is a powerful voice for the voiceless here in the House of Representatives, who has ably served her constituents in Northern California and consistently fought for a fair, equitable society. Let me now yield to my good friend, the distinguished gentlelady from California, Representative Barbara Lee.
Thank you. Let me thank the gentleman from New York for yielding, but also for your tremendous leadership. You and Congresswoman Joyce Beatty from Ohio really have sounded the alarm, beat the drum, and really brought to the American people the important issues that we're dealing with each and every day. So I just have to thank you for your diligence and for staying the course. Every week you're here really representing not only this Congress but the country very, very well. So thank you. I rise today with all of my colleagues in the Congressional Black Caucus, with our whip, Mr. Hoyer, and others to urge our Republican colleagues in the Senate to, of course, do your job. Also, let me just remind us that, once again, the President is trying to meet his constitutional obligation once again. He's trying to do what he is supposed to do, and that's nominate Justice Scalia's replacement to our nation's highest court. And Senate Republicans have a constitutional responsibility to give the president's nominee a speedy and fair hearing, followed up with a simple up or down vote. Sadly, these Senate Republicans have said no to their constitutional responsibility. The Supreme Court has the huge responsibility of deciding cases that impact every aspect of American life, from our elections and college admissions to scientific patents and a woman's right to make her own health care decisions. It's imperative that the Supreme Court be allowed to function in its full capacity with 9 justices. Former Supreme Court Justice Sandra Day O'Connor, who was appointed by a conservative president, President Ronald Reagan, she did not mince words in her condemnation of Republicans playing politics with the court. She said, "We need somebody in there to do the job and just get on with it." Former Justice O'Connor, I could not agree more. Despite the calls for action and the constitutional mandate, Senate Majority Leader Mitch McConnell of Kentucky has said that there will be no hearings, no votes, not even a meeting with President Obama to discuss the late Justice Scalia's replacement. That's just wrong. His actions prompted the New York Times to editorialize that he, and I quote, seems to have lost touch with reality and the Constitution. Speaking of Majority Leader Mitch McConnell. Mr. Speaker, I'd like unanimous consent to insert a couple of New York Times articles into the record.
Without objection.
Thank you. The title of these articles, one is Black Sea Bias and Delay on Scalia's Successor. The other one is New York Times article, Senate Republicans Lose Their Minds on a Supreme Court Seat. Likewise, Judiciary Committee Chair Charles Grassley of Iowa led a letter to Majority Leader signed by all of the Republican committee members confirming their resolve to not have hearings or a vote on the nominee. This is downright ludicrous. Republicans cannot and should not use the Supreme Court to push their radical political agenda. The Constitution is clear, Mr. Speaker. Article 2, Section 2, he shall have the power by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers, counsels, and judges of the Supreme Court. Nowhere in the Constitution does it say except in an election year or except when the president is a Democrat or when Republicans have spent the last 7 years actively working to subvert every policy that a president elected by nearly 70 million Americans. Constitution doesn't say that. This is simply unacceptable, and the American people deserve better. For more than a century, every single Supreme Court nominee has received a vote on the floor of the United States Senate. Just like all the presidents before him, President Obama should nominate a Supreme Court justice, and the Senate should determine if he or she are fit to serve on this nation's highest court. Instead, Republicans are holding the Supreme Court and the American people hostage. Their action, in the words of the New York Times, is simply, quote, and I quote, panic masquerading as strength. The Senate has a responsibility to at least consider the president's Supreme Court nominee, And by refusing to do so, they are failing their constituents and their nation. So, Mr. Speaker, it's really past time for Majority Leader McConnell and the rest of the Republican leadership to do their jobs and work to get a new Supreme Court justice. The Supreme Court is way too important to be used as a political bargaining chip. Enough is enough. So once again, I join my colleagues, Congressman Jeffries, Congresswoman Beatty, members of the Congressional Black Caucus, and the American people in saying, do your job. With that, I yield back, and once again, thank you for giving me the opportunity to join with you tonight.
Thank the distinguished gentlelady from California for making several important points as it relates to the absence of any partisanship exception in the United States Constitution, the absence of any exception whereby the Senate will do its job unless, of course, President Barack Obama happens to occupy 1600 Pennsylvania Avenue. I see that nowhere within the four corners of the United States Constitution. I don't see an election year exception in the United States Constitution. And so I'm perplexed as to what is the situation we find ourselves in right now. And I thought that I may ask the distinguished gentlelady, my colleague, my co-anchor from Ohio, to reflect upon, if you might, a few comments that could shed light on the situation we find ourselves in right now as it relates to the Supreme Court vacancy made by Senate Majority Leader Mitch McConnell over the years during his time here in Congress. In 1986, Mitch McConnell said, "I believe that a heavy burden must be met by those who would have this nominee rejected. Under the Constitution, our duty is to provide advice and consent to judicial nominations, not to substitute our judgment for what are reasonable views for a judicial nominee to hold." That was in 1986. And then in 1990, he said, "It is clear under our form of government that the advice and consent role of the Senate in judicial nominations should not be politicized." That was Mitch McConnell in 1990. In 2005, he said, "Our job is to react to that nomination in a respectful and dignified fashion. And at the end of the process, to give that person an up or down vote, as all nominees who have majority support have gotten throughout the history of the country." I'm trying to figure out what has changed. Representative Beatty.
Thank you so much, Congressman Jeffries. Hearing you quote those things, three things come to mind. First, let me say that Congressman Steny Hoyer was absolutely right when he says this issue of not filling the vacancy is not related to only one group. So I wanted to say, after hearing what you've said and many others of our members of the Congressional Black Caucus, it's important for us to know why we are calling on the Senate Republicans to do their job. And that's because we are the voice for those who are not often represented. We are the voice for those when you talk about issues related to women and women's rights, when you talk to or about issues that are related to things that affect you and I. And then when I think about the article that Congresswoman Barbara Lee entered into the records, blacks see biases in the delay on a Scalia successor. Now that article says it all. That article specifically states that many folks believe in this wonderful America that we live in, that it is also because of the color of his skin. And I think that is another reason that we come as a strong 46 members of the Congressional Black Caucus, because the facts work against them. Think about it. When we look at the number of people who have been appointed, when we look at the number of days, if you look at since 1975, it's only taken an average of 67 days to confirm a president's nominee to the Supreme Court. The Senate has never taken more than 125 days to vote on a Supreme Court nominee, and there are 325 days left. in President Obama's term. Since the early 1900s, 6 Supreme Court justices have been confirmed in an election year. So when I think about your question, and I think about your sharing with us some of the comments that Senate Majority Leader Mitch McConnell has said, let me add this one to the record. And it's something he got right. He said that the American people should have the right to choose the president who will pick the next Supreme Court justice, deciding the future balance of the nation's highest court. Well, he got that right. Because you know what? The president, the people did pick the president when they picked President Barack Obama in 2012, who won the election by 5 million votes. So I'm calling on him and the Senate Republicans to do their job, to allow the president to do what the Constitution tells us, to allow the president, who has already said that he's going to bring somebody who is full of scholarship. He's going to bring someone who is committed and capable to doing the people's work. So I wanted to add that to your statements and share with everyone tonight. That's why we're here.
And I really appreciate that. As we are simply trying to point out, all we're asking for is for the Senate to adhere to its constitutional responsibilities, and when the president sends forth a nominee, conduct a rigorous hearing process before the American people, and then at the end of that process, provide that nominee with an up or down vote before the Judiciary Committee, and then ultimately the floor of the United States Senate. Now, I've been in this institution for a little over 3 years, and if I had $1 for every time some of my colleagues mention strict adherence to the United States Constitution, I'd be a billionaire right now. And for the life of me, I can't understand what's so complicated about this particular issue. As Representative Beatty so ably pointed out, from this moment, there are 325 days remaining in the presidency of Barack Obama. And as this chart illustrates, if you just take a look at the current occupants of the Supreme Court, Justice Roberts, the Chief Justice, most important position on the Supreme Court, a 23-day confirmation process. Justice Scalia confirmed in 85 days. Justice Kagan, 87 days. Justice Sotomayor, 66 days. Ruth Bader Ginsburg, a.k.a. the notorious RBG, I should say. One of my personal favorites, 50 days. Clarence Thomas, 99 days. I mean, you can add some of these confirmation periods together, and you still wouldn't get to 325. So what is the problem? Mr. Speaker, let me ask how much time we have remaining on our special order today.
12 minutes remaining.
Let me ask unanimous consent that all members have 5 legislative days in order to revise and extend their remarks and include any extraneous material on the subject of this special order.
Without objection.
I thank you. One of the concerns that I think we in the Congressional Black Caucus have as it relates to the presidency of Barack Obama, and Representative Beatty pointed this out, is that there's just a feeling in many corners of America that this president is treated differently. And I'm not sure it's because there are some people here in the Capitol that have something against folks from Hawaii. I'm not sure if it's his Kansas roots. I don't know if you dislike the fact that he's a community organizer in terms of one of the jobs that he held after school. I don't know if you dislike the fact that he's so well educated from Columbia and Harvard Law School. I don't know if it's the fact that he was the president of the Harvard Law Review, constitutional law professor at the University of Chicago Law School, a top 5 law school in this country. I don't really know. What is it about Barack Obama that you want to treat him differently than almost any other president who has served at 1600 Pennsylvania Avenue? I'm trying to figure it out. What is it about Barack Obama that he has to be treated with such disrespect? And the amazing thing to me is that you've actually failed to stop this president. You gave him no assistance as it relates to trying to turn the economy around. He inherited a train wreck from George W. Bush. He's gotten the economy back on track. Not a single member from the other side of the aisle voted for the stimulus package, which was necessary to stabilize the economy and then build it up. 71 consecutive months of private sector job creation, 14 million plus private sector jobs created under this presidency. The unemployment rate has gone from over 10% to under 5%. The stock market has gone from 6,000 to over 16,000. Deficit's been reduced by more than $1 trillion. Gas prices are below $2 per gallon. More than 18 million previously uninsured Americans now have health coverage. And not a single one of those accomplishments occurred with a vote from the other side of the aisle. What is it about this president that you don't like? And now, in his final term, and by the way, speaking to strict constructionalists, when you look at the United States Constitution, I can't find a 3-year term. I can't find it. It's a 4-year term with 325 days left. And so all we're asking is that you just do your job. It's pretty simple. Give whoever the president puts forth a fair hearing. You have the votes to defeat any of his nominees. And so let me ask my colleague from Ohio, what I haven't been able to understand is this justice, who I've disagreed with on many issues, although he was strong, Justice Scalia, on the privacy rights of the American people, the Fourth Amendment, was concerned about the criminalization of politics. These are areas where there's some common ground, and certainly he was a giant in terms of legal thought. The news of his demise was barely out for public consumption when Mitch McConnell issues a statement saying, we're not considering anyone that President Obama puts forth. I mean, how do you explain that? How do you interpret that reaction? We couldn't even respect the death of Justice Scalia before the vacancy was politicized, before he was even buried and funeralized.
Congressman Jeffries, I think you answered that question for me. When you gave the long list of successes that this president has done without their help, that gave me pause to think, what is it that's keeping them from doing their job? Why is it that they are so threatened? And maybe it is the success that this president has brought forth, not for you and I, not for the 435 members of us, but he's done this for this nation. He's made it a better place. And when we look at what the justices do and represent, when we think about liberties and freedoms and the economy and our rights, I think they're afraid that he will appoint someone who will have that same scholarship, who will have that same success, someone who will bring balance, I think they are afraid of the balance. And in the words of another one of our colleagues, I might add from the great state of Ohio, Congresswoman Marcia Fudge, former chair of the Congressional Black Caucus. She has words that she's entering, but I'd like to quote from her words to remind us why we are saying, Senate Republicans, do your job. She reminds us as members of Congress, we made a promise to our constituents that we would faithfully discharge the duties and the oath of office which we took, which we were elected to. And so she reminded me in her words that it is so important for us to say tonight to the Senate, do your job. Do your job. I think they are afraid, so I'm going to issue a challenge. Congresswoman Barbara Lee said that you are here tonight initiating this topic because we are sounding the alarm. We are ringing the bell. So I challenge them to answer that question. I challenge them to share with not only the Congressional Black Caucus, not only the members of Congress, not only the members of the Senate, but they have an obligation to America, to the citizens of these United States, Mr. Speaker, for them to tell us why they're not doing their job.
I thank the distinguished gentlelady for those very powerful words, and I can only hope as we close this special order hour that our colleagues from across this Capitol will see fit simply to adhere to their constitutional responsibilities to consider any nominee put forth by President Obama comprehensively and fairly, and to faithfully execute those obligations consistent with their oath of office, not for the good of this president, not for the good of this Article I Congress, for the good of the United States of America. And with that, I yield back.
The gentleman yields back.
Mr. Speaker, I move that the House...
The gentleman in New York rise.
Thank you, Mr. Speaker. I move that the House do now adjourn.
The question is on the motion to adjourn. Those in favor say aye. Those opposed, nay. The ayes have it. The motion is adopted. Accordingly, the House stands adjourned until 10 a.m. tomorrow for morning hour debate.